Welcome back. We are following a domestic abuse hearing for military wife murder trial defendant Jordan Henning.
Now, Henning was found guilty of manslaughter in the shooting death of his wife, Ashley, and was sentenced to 20 years in prison. But at trial, Henning testified that he broke during a fight with Ashley after allegedly enduring years of abuse.
And that's important because Kentucky law allows victims of domestic violence to seek parole eligibility after serving half of their sentence. So the question for the judge, did Henning prove that he was a victim of abuse by Ashley? Let's go back into the courtroom now to hear what the judge's decision was.
The court has considered all the trial testimony. I went back and reviewed some of the testimony prior to the hearing. Specifically, I think I reviewed all the video that was introduced with specific segments of it. I've seen the entire video, as I think I stated on the record at one point in time, way too many times. I've been doing this for a little bit. Sometimes when you make these decisions, I don't get nervous because TVs are here, people out there, you're used to that. You do this kind of job. I think you get nervous in this job when you want to make the right decision. You're nervous when it's either or real close. I think I got nervous yesterday at Commonwealth, and I think I'm still nervous. I'm not so sure I should have completely revoked that young man's probation yesterday. But we'll see on that. How about that? I think I'm still nervous about that. I'm nervous about that. I'm not nervous about this. I'm not going to be nervous about this one because it's clear to me. Mr. Henning is not a victim of domestic violence. Domestic violence, according to KRS 403.7202A, defines domestic violence and abuse as physical injury, serious physical injury, stalking, sexual abuse, strangulation, assault, or the infliction of fear of imminent physical injury, serious physical injury, sexual abuse, strangulation, or assault between family members or members of an unmarried couple. He must prove that there was domestic violence or abuse by preponderance of evidence. Now, again, that's lower than beyond a reasonable doubt. It's one of those things you call in civil cases more than 50%. I do not find that he has overcame that burden. I'm in agreement with the Commonwealth. I've got a video. These domestic violence cases, most time these cases come, they get to our Court of Appeals or our Supreme Court generally in family law cases here in our jurisdiction. People may know we have family law or family court judges that hear those cases. This court hears them some, so is versed well enough in those cases and has reviewed all those cases. In most of those cases, well, maybe a little bit more nowadays, you kind of have some videos. We have video this night of an extended period of time that shows that actually Mr. Henning was the domestic violence aggressor. I did not see anything in that video. And like I said, I've reviewed that, I'm going to say at least a half a dozen times, in either the majority of it or these specific portions. There was nothing, and I mean nothing, in that video from Ms. Henning that indicates to the court that there was any domestic violence on her part. Now, I do understand that that was a snippet in time. However, here's what the court is saying. The impact of that evidence, direct evidence of Mr. Henning's domestic violence against Ms. Henning, the court can easily draw an inference from that on any of these other alleged occasions you, sir, were the aggressor of domestic violence. Now, the evidentiary allowances for hearings like this, hearsay can come in and things of that nature. Just to be honest with you, I would have to believe you, sir, and only you, because there is no corroborating testimony in regards to you suffering physical violence. Your mother didn't corroborate. I have not heard anything in addition today to corroborate. I did not hear any Now, everybody has issues in any relationship, marriage or otherwise. Could there be yelling? Could there be screaming? Could there be, taking you something and throwing it up against the wall? Okay, that is not physical abuse or violence. Now, it could go to the level of possibly infliction of this fear of imminent, but it must be imminent. But to even believe that, I've got to believe you, and sir, I don't believe you at all. I just don't believe you. It's easy, folks, easy. There's nobody here. There's no jury. I'm not doing this. I'm just saying, for the record, I don't believe you. I would have to believe you. There's no other corroborating testimony, okay? And without that corroborating testimony, you can't get over your burden of the preponderance of the evidence. Your counsel, Mr. Rigby, is correct that there are these subsequent findings, but I don't get there if I don't find that you were a victim of domestic violence. I do not find, by preponderance of the evidence, that any of the testimony, any of the documentation, any reasonable inferences that I can draw from that leads me to make a factual finding that you were a victim of domestic violence. Because of that, I will deny you the exemption because I do not believe you get to the second portion that find this incorrect. It's a nexus between the domestic violence and the crime, because I do not believe you were a victim of domestic violence. With that finding, I will deny the exemption. I'll get out a written order, and that will conclude the matters in this case with a corresponding judgment, so that any issues concerning the containing of this order with that judgment begins in the appellate time for you to speak.
Michael, I just have to say, you heard the applause in the courtroom when he issued his finding. He is not finding him a victim of domestic violence. Two reasons. Number one, he didn't believe the defendant. And number two, there was no evidence to support what the defendant said was true.
No corroboration. And I had asked the question earlier of our guest if he thought that the entire record would be something the judge would consider. And he did. He said, I considered the entire record, including the videos.
Yes.
And in those videos, you, Mr. Henning, were the aggressor, were the abuser. At least that's the way it looked to the judge.
Yeah, absolutely. He said that more than once, that video showed he was the domestic violence aggressor.